Hey everybody, hope you're all doing well. You may have heard about this right to disconnect law that just passed last week in Ontario. The right to disconnect meaning not having to communicate with your workplace after work hours, whether that be through emails or calls. And this has gotten a lot of attention because of the prevalence of remote work in the past 2 years, where the lines between personal time and work time has gotten blurred, much to the detriment of the work-life balance of a lot of people. And the resulting burnout has definitely contributed to what's been going on in the labor market recently, now popularized as the Great Resignation. But what you may not have heard is that this law that was passed does not actually guarantee you that right to disconnect. And so it being called the right to disconnect is pretty misleading of what this law actually does. Before I get into it, here are the timestamps for this video so you'll know what I'll be talking about. And as always, nothing I say here constitutes legal advice. So when I first heard about this right to disconnect law in the news, I was pretty pleased because I generally favor rights that empower workers, especially when it comes to employment contracts. Because those are almost always drafted by companies, and so they give themselves so many rights and advantages, and by consequence, the employee gets very little. However, when I actually then took a look at this law that was passed, the Working for Workers Act, I was disappointed because it doesn't really give employees the right to disconnect. If we understand rights to mean the legal entitlement to something or freedom from something, this law definitely does not provide that for disconnecting from work. What it actually does is force all employers in Ontario that have 25 or more employees to create a written policy for disconnecting from work at their company, and to make that written policy available to the employees. But this law tells the employer nothing about what the policy actually has to be. And so in theory, your employer could give you a written policy that says you have to respond to calls and emails anytime as necessary, and that would be your quote-unquote right to disconnect, essentially meaning you have no right to disconnect at this workplace. And so this was highly disappointing to me that all this law is doing is forcing employers to write down their policy but not actually giving them any minimum standard on disconnecting from work to comply with, so as to actually protect employees. And that was my initial expectation of what it would do, because this new law is part of the Employment Standards Act, the main law protecting workers' rights in Ontario that sets out other standards like the minimum wage, maximum work hours, overtime, vacation, etc. And just for clarity here, the reason why setting these standards is important is because employers are always forced to comply with at least these bare minimums required of them to not get sued. So if anything is mandatory by virtue of the Employment Standards Act, they have to follow it. But with this new law, all they have to do is comply with writing down their policy, and whatever that may be. So what does this mean for most workers in Ontario? Your employer will have to provide you with their written policy on disconnecting sooner than 6 months after this law is final via royal assent, meaning by the beginning of June 2022. And my guess is that in all likelihood, the written policy that your employer will make is just going to reflect what they are already doing with you right now. And so if your employer already does a good job of letting you disconnect from work, great. But if your employer doesn't really let you disconnect from work, the ability to do that to you is a right they are going to give themselves in this new written policy. And so you basically are going to still have to comply with it. So yeah, frankly, this is not anything to get too excited about if you're a remote worker who has been hoping for some regulation to support your work-life balance. But to look at this objectively and from multiple perspectives, I will offer some points in favor of why the Ontario government did this, as in why it may have made sense to do it in this way. So first, one reason they may have made this law so weak in terms of actually protecting the right to disconnect for employees is that it's a new change in response to a relatively new phenomenon of mass remote work. And so from the government's point of view, you can't realistically enact a new change that's too big and make it enforceable on thousands of employers across Ontario, because it would likely cause too much mayhem in ensuring employers comply with it and also monitoring that, and most importantly, it could be politically unpopular. Because at the end of the day, this is not like a campaign promise that they're delivering on, this is a fairly new issue. So any big change has to gradually be put in place over time, because democracy is slow, that's just how it works. And another reason they may not have put in place any specific standards is that workplaces are different and complex. And so they can't really say you have to allow workers to disconnect for, these specific hours, or these types of communications are okay, but these are not, because that would not be applicable to all employers. You have to give employers the flexibility to run their specific type of business. Now, in my opinion, while it may not have made sense for them to put quantitative standards in place, they could have at least put some qualitative standards. For example, what if the law included something like the written policy on the right to disconnect has to be reasonable in the context of each employee's responsibilities. And so there, what's reasonable could be assessed on a case-by-case basis. So, for example, a policy requiring emails and calls to be answered at any hour of the day may make sense for an executive of a company, but that would not be reasonable to expect of an intern or a junior person at that company. And so the company should have a different, much more relaxed disconnect policy for this latter group. And one other potential reason why the government didn't put any standards is because they honestly don't know what the standards should be, and they're using this initial law to find out more information to then devise a policy on. Again, because this is a relatively new issue, they could simply not have the data about what the common policies are right now in private company workplaces across Ontario when it comes to disconnecting from work. And so by forcing employers to generate this written policy all across Ontario, this now presents an opportunity for them to collect data about what is popular and what the outliers are when it comes to these policies at different employers' workplaces. And then they can use that data to create standards based on different industries and positions. To speed up this process, the government can then pass regulations under the Employment Standards Act to then fill out the substance of what these right to disconnect policies must contain. Again, these are all just my own thoughts of why the government created this law in the way that it did. And in announcing it, the Labor Minister did call this a start. So frankly, this is my charitable interpretation of that. Okay, now let's consider the upsides. How can you as a worker benefit from this law? Well, at the start of the video, I mentioned the Great Resignation, the unprecedented amount of workers that are quitting their jobs because their priorities have changed in the past 2 years and because they want better pay for their work in the face of growing inflation. The result has been a record labor shortage, with Statistics Canada saying that the job vacancies in Canada has just surpassed 1 million jobs. So what this tells us is that not only are people quitting their jobs, but they're also being much more selective about the new jobs that they're willing to take on. While the most important usual factors for a prospective employee that's job hunting is going to remain the wage and benefits that employers offer, now you have this written disconnecting from work policy that you can use as well to make your decision. Because looking at the employer's disconnecting from work policy can help you gauge what the work-life balance at this job is really going to be like. So when you're inquiring about a position or interviewing for a job, you can ask the employer, what's your disconnect from work policy, and then have them give it to you so that you can assess it. Just to be clear, this law doesn't actually say that employers must provide their policy to people who are not employees. So a person inquiring or interviewing for a job is not legally entitled to it. The law does say new employees have to be given the written policy within 30 days of being hired. But if an employer is not going to be upfront about what their disconnect from work policy is, in my personal opinion, and not any legal advice here, it's a red flag. I believe that an employer should make it clear what the expectations are going to be for you in the role that you're applying for. And that would include their expectations of communicating with you outside of work hours. An employee should never have to be surprised about what their role fully entails. They should be informed fully before they consent to the work. Of course, just remember that Ontario employers have until June 2022 to create this written policy. So if you're job hunting right now, they may not have a policy to actually provide you. But this is something that employers should have at least started thinking about so they can at least give you an idea of what their policy will be like. Another possible upside to this law is that some employers will create disconnect from work policies that are actually very employee friendly. Keep in mind I said some, not all, just some. And the reason they would do this, despite not actually being required to make the policy this way by the law, is because some employers are just better at reading the room and understanding the work environment. There are a million job vacancies in Canada. A lot of people are not going to work for you unless the opportunity sounds inviting. So there's much more competition among employers for workers. How then can you attract and retain the best talent in such a competitive environment? If you're not a massive corporation, you only have so much of a budget to pay them. So what else can you do? You can give your employees an actual right to disconnect at your workplace. And so some employers will understand that and want to get ahead of the curve in doing that, realizing that eventually the law will start mandating some minimum standards. And so for those employers, instead of drafting their disconnecting from work policies like most other clauses in an employment contract, where the employer can do X, Y, and Z at their discretion, including communicating with you outside of work hours, these savvy employers will opt to make actual prescriptive rules and boundaries for when they can contact you for your benefit. So that's just what I think about this law. That's not a really right to disconnect law. Even though this is only passed in Ontario, history tells us that the other provinces will probably make their own version in the near future, and perhaps their version will actually have some substance to the disconnect from work policies required by employers. As the final part of this video, I just want to quickly touch on two other changes created by this Working for Workers Act that may be useful for you to know about, again, both relating to the workplace. And unlike the disconnecting from work law, which obviously left me pretty disappointed, I think these are both positive developments that I'm happy to see. The first is that non-compete agreements are no longer valid under the Employment Standards Act. Non-competes are usually provisions found in your employment contract, and what they do is make you agree to not compete with your employer's business once you leave that job. So if you have a non-compete clause in your contract, it's no longer binding on you unless you're an executive or it's in the course of the sale of a business. Keep in mind though that even before this law was passed, a lot of these non-compete clauses were unenforceable to begin with, meaning they were not actually valid under law, despite employers including them in their contracts. Because when there were lawsuits on the basis of these non-compete clauses, the majority of court cases found that they were not legal, especially because a lot of them would have huge scopes. For example, not allowing the employee to compete with their former employer's business for years and extending to all of Canada. So it comes as no surprise that these non-competes are now prohibited because first off, it's just not to the benefit of society to allow companies to restrict the freedom to work of their ex-employees just because their knowledge and experience happens to be in the same area as their business. And also because employers already have other legal tools that are sufficient to protect themselves from an ex-employee unfairly competing with them. For example, confidentiality clauses regarding their intellectual property and non-solicitation clauses that prevent an ex-employee from poaching their customers or other employees. But again, I'm glad this law was passed because there was still uncertainty about non-competes for employees and how they would affect them. Despite the fact that many of these non-competes were not legally valid, employers would still include them in their agreements, and employees would be afraid of these clauses, to the point that they would forego working for their ex-employer's rivals or change industries altogether to avoid being sued. And so these non-competes could have been unfairly exercising control on how employees could earn a living after they left a job. But now we have clarity that all of these non-compete provisions are not legally valid in employment contracts. And importantly again, now in the context of this Great Resignation environment, if you as an employer are not doing enough to retain your employees, you can expect that they will quit and go work for your direct rival competitor who is offering them more than you are. And to be honest, I think that's a good thing. Now, theoretically, you could create a rare situation where an opportunist, unethical employee keeps either leaving jobs or threatening to leave by going to work for competitors. But realistically, you can only leave jobs so often before no one wants to hire you because you're just not reliable to stay. And secondly, when an employee is threatening to leave, it ultimately comes down to the employer to decide how valuable they are for your business. If they are incredibly important, you satisfy their demands, and if they aren't, you can let them go. And just lastly, a law about washrooms. Yes, you heard that right, washrooms. So now, under the Occupational Health and Safety Act, the owner of a workplace shall ensure that access to a washroom is provided on request to a worker who is present at the workplace to deliver anything to the workplace or to collect anything from the workplace for delivery elsewhere. So what that means is when a delivery driver asks to use the washroom at your workplace, you have to let them. You know, this is the sort of rule you might expect to see written on the chalkboard at a kindergarten and not by the Ontario legislature. The absurdity aside, it's not hard to deduce why this has become an issue. In the past 2 years, we've had a huge increase in deliveries and thus delivery drivers. These drivers are constantly going from place to place, and unless they return to their HQ or home, there's nowhere for them to use a washroom. And so they'll be asking to use the washroom of one of the delivery pickup or drop-off locations, and presumably enough of them were being told no that this became important enough to codify in legislation. But the story doesn't end there, because this right to a washroom has exceptions. Yes, exceptions, where the workplace can say no. And so when can the workplace say no to the delivery driver who wants to use the washroom? If providing access would not be reasonable or practical for reasons relating to the health or safety of any person at the workplace, including the worker who requests to use the washroom, or if providing access would not be reasonable or practical having regard to all the circumstances, including but not limited to the nature of the workplace, the type of work at the workplace, the conditions of work at the workplace, the security of any person at the workplace, and the location of the washroom within the workplace. So basically every potential reason you could want to use to say no to the delivery driver is included as an exception in the very same law that gives the right to be granted access to workplace washrooms. Cool, that makes a lot of sense. Nice job, Ontario. While I can understand the exceptions to not allow access to washrooms for delivery drivers for sensitive places like schools or retirement homes, The exceptions are just worded too broadly. If, let's say, the workplace is an office, they can say our work involves confidential information. We can't just let you walk around here to get to the washroom. If it's at a factory or an industrial area, they can say, sorry, this isn't a safe place to be walking around without the proper equipment. So realistically, delivery drivers are basically limited to asking to use the washrooms of customer-facing workplaces like restaurants and stores. And if that was going to be the case, why not just put that as the law instead of opening the door to this negotiation over bathrooms? I don't know. Anyway, I hope you found that all useful or interesting, and make sure to give this video a like and subscribe. Until next time.